You cannot discriminate the father of the child just because they didn't give birth to the child. So the Constitutional Court judgment of Van Wyk says there should be equal sharing of parental leave.
Yes.
Hence, you will see that with the amendments, the mother cannot go back to work before 6 weeks because they've given birth.
Yes, yeah.
But there should be a discussion between the father and the mother in relation to how they will equally share the parental leave of 4 months and 10 days.
At Dell Podcast, your auditory experience on employment and labor news.
Welcome again to At Dell Podcast, where you hear all information about the Department of Employment and Labor. Today we have a beautiful guest, Dr. Nzwaki Mamashela, and congratulations to you, Doc, for obtaining a PhD. We are very proud and very excited. You may greet our our viewers as well on the podcast.
Good morning to all the viewers and parties that are interested in the labor market issues.
Absolutely, no. Thank you very much. Now, there's a lot of work that is taking place at the department, especially within the legislative framework, because our work is to ensure that we produce the legislation so that it can be applied and we also enforce it. But today, we are talking from a labor relations perspective. And we're also going to be talking about unsafe work, unfair deductions, and gaps in protection for workers in new types of jobs. And I'm told these jobs are real challenges in the labor market. The department is proposing amendments that speak directly to the issues from shared parental leave to protections for all on-call and zero-hours workers, to stronger enforcement and wider coverage for people who work like employees but are labeled as contractors. So these are the issues that we'll be unpacking today in terms of the Labor Laws Amendment Bill, as you know, and the Labor Relations Amendment Bill 2025, as well as recent departmental notices that aim to strengthen protection for employees and workers, particularly those in vulnerable or unsafe work arrangements. Now, Mama Shel, or should I say a doc? Mama Shel, I'm very excited to be within your midst. Now, we just want to talk really to the Labor Laws Amendment Bills in terms of what is that they are seeking to really address and achieve where we were. I mean, we can talk about amendments in relation to BCA, Employment Equity Act, Unemployment Insurance Act, National Minimum Wage Act, as accompanied by the Labor Relations Amendment Bill 2025. Now, these reforms, I'm told, they are designed to strengthen protection for employees, especially those in vulnerable positions, as we've indicated. Now, the question that comes to mind, and I think even the viewers will want to know really, what prompted these changes and what problems were they really trying to address? Maybe if you can just give us a scope that really brought about the need for amendments.
The recent labor reform process was conducted together between the network social partners, government, organized labor, and organized business to actually review the current labor market regulation or the labor law legislation, cutting across the different labor laws that we have in South Africa to ensure that we support the government's intention to fight unemployment, poverty and inequalities that are persisting in the labor market, We also wanted to improve the protection around the rights of workers that are in atypical forms of employment, especially the emerging trends of the gig economy workers, and those we know in South Africa, the Uber drivers, and now recently there are emerging atypical forms of work where we have on-call workers. Those that come in only when there is work, and they are called now on-call workers. These are new emerging trends in the labor market. We also, with this labor law reforms, wanted to improve the efficiencies in dispute resolution between the employers and the employees, and at the same time reduce regulatory administrative burden on small businesses, so that we make it easier for small businesses to grow and create jobs, to address the issue of unemployment, and at the same time also comply with labor laws.
Absolutely.
And another area which was also important was to make sure that our labor laws keep abreast of the latest court cases, that the judgments that came out of the different labor courts, inclusive of the Constitutional Court, to ensure that we are not lagging behind in our regulatory framework.
Absolutely. No, but that's interesting, because that means we need to keep abreast of the changes, the changing times, and I like the fact that you mentioned the social partners, because the network social partner experience and engagement are quite important, because they involve everyone in terms of making sure that the different sectors of our society are taken care of. Now, you've mentioned gig work. I know there's something called platform work as well. So there's a whole range of type of, world of work out there in terms of execution of types of work. So, but there's also an interesting thing that I've seen or heard about that relates to, leave, a family responsibility. I mean, there's a thing called shared parental leave and expanded family coverage. Now, the key changes, as I've seen, are more equitable parental leave, replacing fragmented paternity and parental leave with shared parental leave model. Now, can you just give us a sense there as to how does this work? There's a father, there's a mother, then there's a child that is born, but both of them needs to be on leave to take care of this child. How does that work, this parental leave, shared parental leave?
Thank you. We need to explain where this emanates from. There is a recent Constitutional Court judgment of Van Wyk versus the Minister of Employment and Labor, where the challenge was on sharing of equal parental rights between the father and the mother of the child.
Yes.
And if we all recall, the current provisions of the Basic Conditions of Employment Act gives 4 months maternity leave to the mother that gives birth to the child.
Yes.
And then there will be 10 days to the father for paternity leave.
Yeah.
Now, with the recent judgment, it creates flexibility and sharing of equal parental rights between the father and the mother. Meaning that we are no more now, with the recent amendments of the Basic Conditions of Employment Act, is that we are changing also the terminology from maternity leave to parental leave to be all-inclusive in relation to the sharing of equal rights to the child between the father and the mother. This creates actually flexibility, and it also helps us to comply with the Section 9 of the Constitution regarding equality. You cannot discriminate the father of the child just because they didn't give birth to the child. So the Constitutional Court judgment of Van Wyk says there should be equal sharing of parental leave.
Yes.
Hence, you'll see that with the amendments, the mother cannot go back to work before 6 weeks because they've given birth.
Yes, yeah.
But there should be a discussion between the father and the mother in relation to how they will equally share the parental leave of 4 months and 10 days.
Okay, so they've combined the two.
We have combined the 4 months, which was previously maternity leave, and the 10 days for paternity leave.
Yes.
We are now calling it 4 months and 10 days for parental leave.
Okay.
If there is an agreement between the father and the child that they will equally, 50-50, they will equally share
Yes.
the 4 months, 10 days, then it means the mother will take the 2 months and 5 days, and the father will take the rest of the
latter part.
two months and the 5 days. But we should all remember, the Basic Conditions of Employment Act does not regulate payment of parental leave.
Yes.
We don't regulate the payment of maternity leave currently.
Okay.
The mother was claiming benefits for maternity
Yes.
under the UIF, the Unemployment Insurance Act. The same approach here is that for parental leave of 4 months and 10 days, they will have to claim the 2 months and 5 days
Or for their
benefits at under Unemployment Insurance Act, or unless the company has a policy that says they will pay for the parental leave.
Okay, now I see. Now, but interestingly, let's just throw the bone in and create a bit of havoc. What if both parties, the mother and the father, disagree? There's no agreement in terms of how to use and share. You said they could share it 50-50. But if there's a discord, or if they don't agree on how to share the leave, is there a remedy? Is there a best way to address this?
If they cannot agree between the father and the mother, in that case, the birthing parent, which is the mother, has the final say.
Okay.
She may take the full 4 months, leaving the other parent with 10 days.
Okay, see.
The father will then take 10 days, or take less and allow the other parent to take the balance.
Okay.
But this also requires that we encourage the parents to actually reach an agreement. But the law is very clear that the birthing parent will then have a say
In terms
on
of
how the
use.
sharing should happen. And again, we have also looked at the developments in terms of people now adopting children
Yes.
and the surrogacy arrangement.
Uh-huh.
The law takes a more neutral approach in this regard when coming to adoption and surrogacy leave, which must also be split equally
I see.
between the parents
Okay.
if there is no
Agreement.
agreement. Yes.
Now talking about surrogacy and adoption, and you've explained how it works. Let's take it to the office now, to the employer. Now, in terms of HR policies, HR principles and processes, how should employers then prepare from an HR point of view and planning perspective, given that we have this latitude now to also take parental leave if we are surrogate mothers or if we adopt? Can you just clarify us there a little bit?
It's very important. While the labor law reform process is unfolding, we have now published for public comments, and after considering the public comments, we'll be going into parliament debates on the amendments to all these various pieces of labor laws.
Okay.
And in the meantime, employers should start preparing their HR policies in this regard, in relation to previously HR policies were covering maternity leave and then 10 days for paternity leave. So they must start looking at how they will diversify the leave requests that will be coming through, not just for maternity leave. So they need to go back, review and amend their HR policies to cater for parental leave and not only maternity leave.
Okay.
And at the same time, they need to make sure that the employment contracts and the HR systems are also
In line.
with
Okay.
the policies, to ensure that if a request comes forth for parental leave from a mother and then the father later, they are able to
Okay.
check first if there is an agreement. If not, who then has a
That's
say
it,
in relation to how many days or how many months should be taken by the mother.
Okay.
It's very important also for employers to start making arrangements in relation to how they will deal with temporary employees that will be kicking in to take over the work of the parents that will be going on parental leave.
I see.
Remember, currently the employers were just planning for a mother that will take 4 months.
I see. No, that's quite interesting. And you mentioned Section 9B, but now in terms of the reforms that are introduced in that Section 9B, especially when it comes to guaranteed hours, maximum hours, availability period, and notice for shifts. Can you tell us what does 9B, Section 9B, say exactly when it comes to those issues? Specifically, if you refer to Basic Conditions of Employment Act, for example, which provide protection for workers on a call or 0 hours or even minimum maximum contracts. And if you talk from an inspection enforcement services point of view, we know there are those vulnerable sectors like retail, security, hospitality. How does 9B regulate and protect us?
Section 9B now introduces minimum predictability and fairness on on-call workers or 0-hour workers. There are different terminologies that are used by different employers.
Okay.
When reference is made, it says now the amendments are saying that there should be guaranteed maximum hours per period. If you need a worker, an employee to come in as an on-call worker or a 0-hour worker,
Yeah.
you should guarantee them the maximum hours of work
Okay.
for that particular day or for that particular period.
I see. Okay.
If it's a peak period for you in December, if you are in retail, you already know how many hours you need the extra people
Yes.
employees to come in. You cannot say, I'm calling you now, you must be available
Now.
now. The law now, the amendments are introducing a notice period. You need to notify the employee or the worker on time to make themselves available to go on duty, which is very critical in this case.
No. Yes. No, continue,
Okay.
because you just triggered something about a notice period and whatever, but we'll come back to it.
And the notice period is 2 ways. You need to give them a reasonable notice period to prepare themselves to go to work, so that if they have family responsibilities, they are able to plan accordingly, get a care worker to come in, or be able to arrange to take the child to the crash or to the child care facilities that they have for those hours, or to have the grandmother to come and look after the child. But similarly, employers have an obligation to give cancellation notice. If the work reasonable, cancellation notice.
Okay.
So that you don't incur unnecessary expenditure of paying for transport. When you arrive at the retail shop, you are told that you are not needed. Already you have spent money on transport. So the cancellation period is very important.
Okay. Now, that deals with the issue of reasonableness, reasonable notice period and what have you. Now, there are two people involved here, the worker and the employer. Now, in terms of this context, the issue that we're talking about now, how can we avoid abuse by either party in this regard? Remember, you explained that the employer must give reasonable notice period for the employer to be able to take care of the other issues. But from the employer, the worker, him or herself, what is in place to avoid them abusing this arrangement? Is there any?
There are conditions that are in in the amendments that we are proposing that a reasonable notice creates flexibility, but it also needs to be on condition that
Okay.
the nature of the employer must take into account the nature of the business.
Okay.
If you are in retail, you are able to plan because you have trends in relation to your peak periods.
Okay.
At times, it's not possible always for people in the emergency services to foresee
Okay. It's about planning.
to foresee that they will need extra hands to deal with the emergency. It depends on, it's an emergency service.
Okay.
So the nature of the business must be taken into account
Okay.
when we are dealing with reasonable notice. Again, we need to check if the employer, it was within the employer's control or ability to predict the demand.
Oh, I see. Okay. So the risks and all those kind of things needs to be taken into consideration.
Yes, and also the impact of less notice on the personal life of the employee. If you call me now and you say I must pitch up in an hour's time, consider the impact in relation to other family responsibility that I may have in relation to arrangements with the children, or maybe I'm looking after a sick elderly person. You need to take that into account.
So work-home balance, it's important in this.
Yeah,
regard.
work-life balance
Yes,
is very important.
Okay. No, that's fine. But now that we're talking about how we curb and avoid the abuse and what have you, the cost of living, as they say in South Africa, it's tough. And if you go to other countries, there are people who hold number of jobs, right? Now, in terms of this amendment, how can we deal with the issue of me as a worker or as an employee doing other jobs, more than one job? Can I be restricted? Does the law protect me from unfair restriction from doing other jobs elsewhere?
First, it's very important that the restriction clauses are very clear in the contract of employment of employees or workers.
Okay.
And it should be in writing.
Okay.
So the law says the restrictions are allowed only if the restrictions are very clear, what kind of restrictions are there, and the rationale for the restriction must be in writing. And again, it must be a genuine operational reason in relation to confidentiality and conflict of interest. If maybe they're scared that working for multiple workers, you might take out the business secrets and to their competitors, but they must put it in writing.
Okay. So everything must be reduced to writing, like a contract.
Yes.
It's preferable that it's reduced to writing. Now, there's also an issue relating to the proposal and the increased statutory severance pay from 1 week to 2 weeks remuneration per completed year of service for dismissals based on operational requirements. I think our listeners and our viewers will be interested in this. Now, what is the intention behind increasing severance pay, and what should employers understand about cost implications and fairness principle? I think this is quite a significant, and it touches most of us.
It does. The issue of severance pay, remember, since the inception of the Basic Conditions of Employment Act in 1997, it has always been 1 week's pay for every completed year of service.
Yes.
And now, with the recent amendments, we are saying it has always been a 1 week.
Okay.
But look at the cost of living.
Oh.
Therefore, we are proposing that it should be adjusted to 2 weeks for every completed year of service.
Okay, see.
And we need to reflect the economic realities and the rising cost of living. And we need to make sure that we protect workers that are on daily basis being faced with retrenchment, so that there is fairness and dignity awarded to these workers during job losses.
Okay.
Other people work for over 30 years, and if you give them only 1 week's salary,
Oh.
they will not be able to keep up with the rising cost of living.
Yeah. There's something else, thanks for that. There's something else that I think employers need to understand, because I've also been asked, as I walk around, been asked about a question, and I noted down, it relates to disputes really. If you get to CCMA and bargaining councils, disputes solely about severance pay, now they can be directly referred to CCMA or bargaining council, and I'm told it's about simplifying access to resolutions without needing to challenge the fairness of the dismissal itself. And I think the punchline is there, challenging the fairness of dismissal itself. Now, how will that streamline resolution for workers and employers, in the work environment now?
Previously and even currently now, because these are new proposals in the law
Yeah.
to reduce legal complexity and cost for employees. With this amendment, we are saying employees can go to the CCMA and take a dispute in relation to severance payment
Okay.
without having to combine the fairness of the dismissal and the payment of severance pay.
Oh, separating the two.
Yes, and it will expedite the dispute resolution process.
Okay. Okay.
Then the CCMA can easily focus on the calculation of the severance pay and finalize, issue an award so that the employee is paid what is due to them. And then, rather than looking at the entire dismissal process, whether it was procedurally or substantively fair, and they just do the calculations for severance pay, it actually makes the dispute resolution process easier and faster than it is currently.
Okay. No, that's fine. No, thanks for that. And there's also issues that people talk about of double dipping. Sometimes someone claims provident fund and this and that from different ports. But in terms of the CCMA, the amendments clarify that CCMA awards for unpaid contributions to benefit funds such as pension or medical aid can include interest at the prescribed rate and prevent duplication of claims across forums. And that's where my interest is, this duplication of claims across forums. Now, if we have to put it in layman's terms, what protection does this give employees and what compliance discipline does it require from employers? Because employers are the ones that actually take the money and put it into provident funds. They are the ones, if we leave work, they're the ones that pay to us. Now, how does this assist this amendment?
This is a very important amendment because it protects employees against unfairness of employers deducting the contributions to pension fund and not paying it over to the pension fund. At the same time, the employees lose out on the interest that could have been generated by the pension fund should the money have been paid over within 7 days to the relevant scheme or the pension fund. So with this amendment, employers cannot delay or avoid paying the contributions to the pension fund, to the medical aid scheme, and at the same time, any unpaid amount can attract interest.
Yes, of course.
Which increases also accountability. And workers all need to pursue multiple legal processes for the same claim. If it's dealt with at the CCMA and an award is issued against the employer, they don't have now to be running around trying to contact the pension fund in different forums and fight that the contributions are paid off. And on the side of employers, to comply with this, employers must know with this amendment, they should do accurate and timeous payment of contributions to pension funds, medical aid, and other statutory contributions that needs to happen, either to the UIF. We know there are many employees that get deductions on their payslip for UIF payment, and yet the employer doesn't pay it over to the UIF. So with these amendments, employers have to get their processes streamlined and make sure that they pay this. The strong payroll controls must be put in place.
Okay.
And make sure that they don't incur any interest on unpaid monies that needs to go to pension funds and medical aid, because that will be calculated in when the dispute goes to CCMA.
No, that's interesting, because it's basically also promoting businesses or employers to be self-regulating and adhere to. Now, you've also spoken about NEDLAC, social partners and what have you, and I know issues of, rights, call them rights of workers to belong to unions, and now there's a Schedule 11 extending fundamental rights to more workers. Now, I want us to talk to that in terms of what problem Schedule 11 is trying to solve and why. Because the Labour Relations Amendment Bill extends fundamental rights through the new Schedule 11, as we are told, to a broader group of workers, including those classified as independent contractors or dependent contractors, such as gig workers, you mentioned that earlier, delivery drivers, home-based service, the Uber drivers, and. Now, what is the rationale? What is it really trying to address or resolve?
Currently, there is a key problem where you find workers being misclassified, and individuals are called independent contractors, just working for themselves and offering a service to their client, whereas they actually operate as employees. Especially, I said earlier on, this is prevalent in the gig economy, where workers often lack job security, job protection, and they also lose out on organizational rights. They cannot join and participate in trade union dealings or activities, and also it protects them against unfair dismissal. So these reforms are actually aimed at adapting to the changing nature of work. The reality is that after the COVID pandemic, most people are working in the gig economy, the platform economy.
Yes.
But they are not protected, and the intention is to make sure that we extend the protection under the labor laws.
Well, that's important, because some of us, we go to a restaurant, hook onto the Wi-Fi, we provide services from wherever we are. But now you said it's trying to avoid that schedule, a misclassification. Now, how would someone be known or determined, or this person actually an independent? What mechanisms, what indicators do we use to determine whether someone is truly independent? What signifies that? What elements are there?
We have also amended the definition of an employee to make sure that if there are any elements of control, at times they say you are an independent person, however, the employer still wants to control what time you start work, the quality of the work that you perform, and also they also control the work schedule, the arrangements of how the work is allocated to you. And also, in addition to that, you'll find that most people are seen as independent contractors, but they have no control over the tariffs that are paid for the service that they are rendering.
Well, that's quite interesting. I think we're almost at the last leg of our conversation, which is quite interesting. But I think because we spoke about vulnerable workers, we know every worker is important. A worker is a worker is a worker. But there are those that are vulnerable. Now, when you talk to enforcement improvements in terms of the bills, specifically talking to bargaining councils and CCMA, right? Now, how will this enforcement improvement change the experience of a low-paid worker trying to enforce their rights? Because we're talking about the reforms that improve dispute resolutions, around BCA disputes, CCMA, etc., etc. Just maybe in conclusion, how will those empower us, we low-paid workers?
Thank you very much. It's a very important one because if you look across all the various labor legislations, I will now say we have the CCMA that can actually endorse the compliance order issued by the labor inspectors into an award, which is enforceable. And now also same jurisdiction has been extended to bargaining councils.
Okay.
And if you look on issues of unfair discrimination, you will notice that in the amendment bills, Section 10 has also been amended to make sure that the jurisdiction to deal with unfair discrimination cases can now go to the bargaining council. Currently, it was limited to CCMA and the labor courts. So the vulnerable workers, if they fall within a particular bargaining council and they have unfair discrimination disputes, they can take it to the bargaining council instead of going directly to the CCMA. And this will expedite dispute resolution.
Perfect. There you have it. Quick ones just to talk to the employers as well as workers in terms of all these reforms and the reviews and whatever you. Message to the employers, message to the workers, as well as the unions, as you conclude, what should they be doing next, given this context?
For the employers, organizations and employers themselves, we urge them to embrace the changes. These are good changes that create a conducive policy environment that will help us to create jobs and address unemployment that is so high in our country. And for trade unions, please conduct advocacy sessions and training sessions for your own members so that they understand their rights and what the purpose of these labor laws are, especially those that are in emerging atypical forms of work, the gig economy. Thank you very much.
Absolutely. Thank you very much, ladies and gentlemen. That was Dr. Ntswaki Mamashelo from Labor Relations Chief Directorate, giving us all the ins and outs on the reforms and the bills that have been reviewed. Keep on watching on our social media platforms. Follow us on our YouTube channel at Dell Podcast, as well as the www.labor.gov.za, which is our website for all the information. Keep on following. Let's converse. Let's change ideas and let's get to know more. We are out.